Hi there. My name is Erna Post. I'm the president of local CEP, Communications, Energy, Paper Workers, Local 2025. And it's a special night for us because this local was just constituted a few months ago. And this is actually our very first political event that we're sponsoring. So we're a little bit late to the story. But we have open-minded membership, and we hope that tonight will be the opportunity for everyone to bear witness to what's been happening over the past couple of years. And we ask you to have open minds and probably later on open your wallets as well. But in the meantime, I just want to thank the community partners that have carried this forward up until now. And I will turn it over to Peter Gose, who will be moderating the event.
Thanks, Erna, and thanks to CEP Local 2035 for having us here. It's really, those of us on the support committee who have been involved since the beginning have, had to go through a lot, and one of the things that's made it not just a horrible experience, but also an encouraging experience is the relationships we've built with people along the way. And so we're delighted to be here. We're delighted to see old friends and new in the audience, and to have linked up with other struggles around similar issues here. So
what we would hope is that you go away from tonight not only feeling bad about what you've heard, but feeling bad enough about what you've heard to actually do something about it. And there's certainly plenty that can be done. This whole notion, and it's really great, first and foremost, to see a room full of people who have come out to an event about something called extradition, which is this bizarre legal concept. And what I was hoping to do is give a broad overview of what extradition is and how it operates and the dangers of extradition. Because in many respects, what we're seeing increasingly is that extradition in law is acting in much the same way as the drones are acting, the unmanned aerial vehicles in Pakistan, Afghanistan, where they do not respect national borders, much less the rights that are guaranteed to people within and without those borders. And just as you can be hit by a Hellfire missile pretty much anywhere between Tunisia and China without any ramifications on those who have fired the Hellfire missile from the drone, it's very similar with extradition. Anyone in this room tomorrow could be served with extradition papers at the whim of an overseas government with whom the Canadian government has an extradition treaty. And this would go forward because Canada has treaty obligations. And one of the obligations of the Minister of Justice is to respect those treaty obligations, even if it interferes with your charter rights as a Canadian citizen, as a permanent resident, or as a refugee. So let's start with this notion, extradition. Is it a good thing? Is it a bad thing? And I think that we can all agree on the idea that we do need extradition at some level, because there are quite a few criminals roaming around out there who do need to be brought to justice and should not hide behind the borders of another nation. Let's say, just for example, purely hypothetically, that there's a former president of the United States and a former war secretary and a former vice president of the United States who've recently written million-selling memoirs in which they not only admit to, but are proud of their decision to authorize acts of torture on other human beings in clear violation of both domestic and international law. George Bush, Dick Cheney, and now Donald Rumsfeld have joined the gang, and one act of resistance that you can do is to take their books from the biography and history section and put them into the true crime section, because that is what their last 8 years were about. And what we're seeing is that there is such a thing as universal jurisdiction with crimes such as torture, and so any country on the planet that is a signatory to the Convention Against Torture should be able to initiate proceedings and try and have extradited from the United States to face the crime of complicity in torture Bush, Cheney, Rumsfeld, Kissinger, and a long line, including Obama, Jimmy Carter, and many others who have all been complicit in these crimes. but unfortunately we're not seeing that. But nonetheless, I think we can agree that extradition would be a helpful thing in that kind of a situation. In the same way that the attempt to extradite Augusto Pinochet for his crimes against the people of Chile was initiated, and I think we can see at that level that extradition can be a good thing. But as we often know, the law in its majestic equality forbids both the rich and the poor from sleeping on park benches and stealing food out of garbage cans. And it works the same way with extradition. Extradition doesn't apply to you if you're incredibly wealthy and incredibly powerful. It applies to those who are set aside as the other. A couple of years ago, there was a report that was issued by something called the International Commission of Jurists, which is the leading judges on the planet, essentially. And they've been gathering in one form or another for the past half century and examining where the rule of law, especially in a post-Nuremberg world, Nuremberg being that landmark trial of Nazi war criminals after the Second World War, where that rule of law has gone off the rails. And they have produced numerous reports. They produced a report with respect to the torture states in Latin America and torture under Britain in Ireland in the 1970s and 80s called States of Emergency. And this report, which came out in 2008, explored the use of so-called counterterrorism measures and the effects that they have had on human rights and the human rights regime which was set up to prevent these kinds of crimes after the Second World War. And in addition to their many findings, the most disappointing of which for them was it's not just dictatorships that are taking advantage of the war on terror, it's in fact liberal democracies such as Canada, the UK, France, and the United States, which have taken the lead in eroding consciously human rights protections. And it's gotten to the point, according to the ICJ, that there are, quote now, governments who want to reserve for themselves the power to designate a class of people who are not entitled to the same rights as other human beings. Now, we know that this is not a post-9/11 phenomenon, but increasingly it is becoming a phenomenon which is entrenched in law and laws that we are seeing, whether it's Canada's Anti-Terrorism Act, our security certificate regime, various other security measures which are applied largely to so-called non-citizens, refugees and immigrants. And so it has come to the point now in Canada where you can say something or do something, and that's enough to get you extradited. Now, I don't know how many of you are fans of Mother Nature, but I know that there was a guy named the Prince of Pot, Dave Emery, who was recently extradited to the United States because he sold online hemp seeds to people in the United States. Now, that's legal to do in Canada, but there are laws that were violated in the United States. Whether you know that or not, he was extraditable, and he put up a big fight against that, but in the end he did surrender to the US and is now serving a 5-year term in the United States for doing something that's perfectly legal to do in Canada, regardless of your feelings on just saying no. And so we're seeing now the possibility that governments can snatch you one of two ways. They can take the clearly illegal route of extraordinary rendition, and we know that that has now been made legal for many years in the United States, first under Bush and recently under Obama, who has extended the right of the CIA to see anyone that they see as a threat to national security to be kidnapped and taken to a black site somewhere run by the CIA, tortured, perhaps put before a military tribunal. And also, Obama has authorized the right of the United States government to assassinate any US citizen abroad that it feels is a threat to national security. So that's the landscape in which we're operating. Now, for Obama or France or Britain to maintain good relations with Canada, it doesn't always look good for Mossad or the M16 to come here and kidnap us. And that's why they have other mechanisms, such as the extradition process, through which they can circumvent our laws and our rights to snatch you. How exactly does this work? Well, a government, let's say France, and Rania will be talking about this, will make a request to the Minister of Justice, who is obligated to look at that request and consider whether or not it is a valid request that can proceed. And in most occasions, that authority to proceed is issued. The authority to proceed is issued, an individual is arrested, they are informed that another government is seeking their extradition to face trial for certain charges, and they will go before what is known as a committal proceeding to see whether or not they will be committed to extradition. And at that hearing, there is an opportunity for the judge to look at what is put before them, what's known as a record of the case, and the case can be allegations, it can be hearsay, it can essentially be anything. And just to give you a sense of the strength of the extradition cases that come before the Canadian Justice Minister, in 1999, Queen's Bench Justice Steele wrote, quote, "Evidence at an extradition hearing should be accepted, even if the judge feels it is manifestly unreliable, incomplete, false, misleading, contradictory of other evidence, or the judges feel the witness may have perjured themselves." So essentially, if you can put together an allegation and you believe that there's hearsay, you believe someone is lying, there's perjured testimony, or even that information comes from torture, the line from the Canadian government is, well, it's a democratic country that is seeking your extradition, so we'll keep you in jail here until the battle is over, we'll send you to jail over there, and then you can figure it out on your own. So essentially you're being punished even if you're completely innocent of those charges. You can spend years in jail, you get to France, you get to Britain, and even if you do have a fair trial and you do win, how much of your life is gone? And we also know that if you are perhaps an African American who is living here in Canada and you are sought for extradition to the United States, the Minister of Justice feels that the courts in the United States are free pretty much of racial bias, remarkably, and that you can go down there. And so again, we're weighing your rights against our international relations and how we perceive other nations. And we're more concerned about whether they feel slighted about our decision not to extradite you than your right to peace, security of the person under Section 7 of the Charter. After the committal, and 9 times out of 10 there is a committal, and usually these hearings are very short. They last 1 to 3 days, and that's why Hassan Diab's case is so significant and important, and you'll find out a bit more about that very shortly. Because there's so little for the judge to do. In most of these cases, the judge has been acting as a rubber stamp and basically saying, you will figure this out. However, you do have one more chance to go forward. And the way in which you can fight one of these things is if you can then show, after the committal has been made, that you make submissions to the Justice Minister, who's the minister who issued the authority to proceed. So on the one hand, the minister has said, as far as I can see, it's good to go, but you get another chance to convince me otherwise, even though I've already concluded that it's good to go. The Justice Minister can refuse the surrender if it would be unjust or oppressive, having regard to all the relevant circumstances. The request for extradition is made for the purpose of prosecuting or punishing the person by reason of their race, religion, nationality, ethnic origin, language, color, political opinion, sex, sexual orientation, mental or physical disability, or the person's position may be prejudiced for any of those reasons. Now, it's hard to find legal definitions sometimes for all of those forms of discrimination. We know that they exist, but ultimately that is a political decision. And recently the Supreme Court of Canada, in deciding whether or not to extradite a Roma family back to Hungary, where they would face the kind of persecution that they had fled here when they came here as refugees, they came to the conclusion that at the surrender stage, the extradition process is essentially political in nature. The Supreme Court in Canada is acknowledging that this is a political decision. The minister must take into account the requirements of good faith and honor of Canada in responding to the request under the extradition treaty, and must weigh the political and international relations ramifications of the decision whether or not to surrender. Look at how this system has been set up. The United States wants someone, and it comes down to, do we please the United States or do we not? Do we invade with the United States or do we not? So you can see how absolutely freighted with politics this whole process can be. Now, And the Minister of Justice is in a slight conflict of interest there, having already made a decision to go one way and now is being asked to go another. Now, as we know, there's many problems with the process. I just want to give you a couple of examples of how this has played out in a number of recent cases. There's a gentleman named Adolf Horvath, who is a Roma refugee, also from Hungary, and he came to this country, and he went through a process by which it was found, because of the discrimination and the violence as a Roma that he faced in Hungary, he should not be sent out of this country, and he was a person in need of protection. He had Canada's stamp of approval. He was essentially a convention refugee. Then Hungary came after him years later and said, we want you on fraud. We want you on this, we want you on that. Well, it turns out that in the case against Mr. Horvath, the two key witnesses recanted their testimony because they said that they had given it under duress. They essentially had been coerced into saying one thing about Mr. Horvath which was not truthful. And so there was a conflict set up whereby on the one hand you have the Minister of Immigration saying Mr. Horvath is a person in need of protection, but on the other his committal went through. And so the Justice Minister then sought a second opinion from the Minister of Immigration. And the Minister of Immigration said, well, maybe it won't be so bad if he's sent back. So what's happening to the rule of law when you have a decision that is made through a lawful process in Canada to find you a refugee and you lose that protection simply because another government, which ostensibly on paper, Hungary, is seen to be democratic, and yet as we know, if you are Jewish in Hungary or if you are Roma in Hungary, there is no democracy.
Imagine that one day, out of the blue, you are approached by a journalist who informs you that you are under investigation for a crime that took place about 30 years ago, and that a foreign country will be seeking your extradition from Canada. Despite your insistence that you are innocent, and you are willing to answer any questions within Canada's legal framework, your name and your reputation are tarnished overnight. Life becomes difficult with media camping outside your workplace and some threatening to follow you everywhere, including your residence. Your life is turned upside down, even though you are not charged of any wrongdoing yet. You know that life will be even more difficult if a legal proceeding is started against you, but you persist in continuing your life as usual because you know that you are innocent and you believe that Canada is a country of law. Despite post-9/11 political atmosphere, you still assume that the rights of individuals against unfounded allegations and suspicions are protected. But you soon realize that something very bizarre is going on. You are being followed in an aggressive and intimidating way by cars with tinted windows. Unidentified people appear out of nowhere and start taking photos of you in an aggressive manner. Someone attempts to break into your home. You report all of this along with license plate numbers to the Ottawa police because you naively think that the police are there to help you. But your requests are ignored. In a country of law, you are intimidated and harassed, and you have no one to go to. After more than a year of this, you are arrested. You spend the first month in a solitary confinement, locked up in a tiny cell all day long except for 15 minutes. You have no access to any reading materials, and any books sent to you are confiscated. You get to taste what life is like inside a Canadian detention center. You are hungry because food is insufficient there. You are cold because there are not enough blankets. You cough continuously because of the terrible recycled air from the dryer machines. You are transported handcuffed and shackled to the court, where you are sometimes left for long hours with no food or water. When you are moved to supposedly quote-unquote protective custody, you discover that bloody and disturbing physical violence are very rampant. You and so many others live in these conditions, even though you are presumed to be innocent. You spend over 4 months in detention after an unusual 6-day bail hearing, along with the testimonies of 5 sureties and character letters from numerous academics. You are released on bail under very strict conditions, which include that you can only leave your residence if accompanied by a surety, and you have to self-finance a GPS monitoring system, which costs around $2,000 per month. You find work doing what you have been doing for about 20 years, but you soon get fired after a few classes due to political pressure. Your bank account is closed. You wonder how you are supposed to pay your legal bills and defend yourself if you are prevented from earning an income. You wonder what it means to be presumed innocent if you are already treated as if you have been convicted. You soldier on, relying on the help of family and friends who believe in your innocence and or want to ensure that due process is followed in Canada. You begin to learn more about the case against you. You know from one of the Crown attorneys, before he flip-flopped on this issue, that the case against you is based on information, hypotheses, analysis that the French intelligence service received in 1999. You have no idea how this information came about. You have no idea who said what and under what circumstances. You wonder how hypotheses and analyses become evidence in a court of law. You keep on hearing the Crown prosecutors saying that anything goes because this is an extradition. You wonder whether your government is taking the position that as a Canadian citizen, you have no rights to due process because a foreign country is requesting your extradition. You later know that no one involved in your case knows the source or even the reliability of the intelligence against you. Not the Crown prosecutors, not the Canadian judge, and not even the French investigators themselves, as they admit in one of the court documents. You wonder how can this be used as evidence against you. It is not as if the French investigators or the Canadian government know the nature and the source of the intelligence against you, but are refusing to disclose it. They simply have no idea how it came about. You wonder how can you defend yourself in these circumstances. You also learn that there is handwriting evidence against you. Handwritten documents from your university and immigration files were compared to 5 words on a hotel registration card that is believed to have been written by the suspect. One French handwriting analyst says that you could be the writer. The other says you are the writer. You have no doubt that this evidence against you is fabricated. You know this not only because you did not fill in the hotel registration card, but also because documents used in the handwriting analysis and presumed to be written by you were actually written by your ex-wife. However, you learn that proving this is not a simple matter due to 2 reasons. First, the handwriting analysis submitted by the requesting state is presumed reliable, so the burden is on you to prove that it is unreliable. Second, you don't have an automatic right to call experts to testify on your behalf. Rather, you have to apply to the court first and convince the judge that your evidence is so overwhelming that it can render the case against you wholly unreliable. Your lawyer, Don Bain, puts forward 4 esteemed handwriting experts who filed detailed reports with the court asserting that the handwriting evidence against you is rubbish. After a week of arguments in which the Crown prosecutors pleaded with the judge not to allow you to call these experts, you win the right. You think that Finally, you will be able to expose this bogus evidence against you. But you soon learn that the extradition law gives enormous power to the requesting state, power that investigators in Canada don't have. Soon after the decision, the Crown attorneys request a lengthy adjournment of your extradition hearing, which is now postponed for more than 6 months. In the meantime, you live under strict conditions and you have to pay about $2,000 per month for the GPS monitoring device. You apply in order to alleviate your bail conditions so that you no longer have to pay the hefty cost of the GPS monitoring device, but your application is rejected. After several months, and just before your rescheduled extradition hearing is about to start, you learn that the French investigators and the Crown attorneys are withdrawing the 2 initial handwriting reports against you, and they are filing a new report. You learn not only that you have to start the process of challenging this new handwriting opinion all over again, but also that the Crown attorneys are again insisting that you not be allowed to challenge this new evidence against you. You file an abuse of process, arguing that the manner in which the handwriting analysis was handled reflects bad faith on the part of the French investigators, but the judge dismisses your application because the extradition law allows for that. In the meantime, you and your lawyer start going over stacks of documents that were filed in the court as part of the request to have your residence and workplace searched. To your shock, you discover that not only evidence that is helpful to you has been suppressed from the court, but also that other evidence and the intelligence have been manipulated. You also learn that the French investigators knew shortly after your arrest that your palm prints don't match those left on the car used by the suspect. The French investigators never disclosed this negative result to you or to your lawyer. You also learned that the French investigators knew more than a year ago that your fingertip prints don't match those left by the suspect. Again, this was never disclosed to you or to the court. According to the Crown attorneys, they are under no obligation to disclose any helpful material to you. You also learned that the French investigators have been interviewing different people who know you, but this evidence is not presented to the court because it is helpful to you. Anything that casts you in a positive light or is helpful to your defense is suppressed. Your lawyer presents the above information to the court, along with reports from 3 esteemed handwriting experts who rip the new handwriting evidence against you apart. The Crown attorneys are again fighting tooth and nail to prevent you from calling this evidence. But again, you win the right to do so. But as before, your defense is limited to showing that the handwriting report filed by the French authorities is unreliable. You are prevented from calling experts who demonstrate that you did not fill in the hotel registration card and thus clear you. You sit through 3 weeks of powerful testimonies of leading experts in the field of handwriting, testifying how appallingly unreliable and biased the evidence against you is. Not only this, but you also know that any objective person who has heard the testimonies of these experts would conclude on his or her own that a scientific handwriting analysis would actually show your innocence. While you wait for the final decision, you wonder whether the case against you would still have proceeded had Canada's extradition laws been fair and just. When you reflect on your experience, you wonder whether the case against you would have proceeded if it were not for the post-9/11 political atmosphere. When you hear the Crown attorneys insisting on using rubbish handwriting analysis opinion against you, you wonder what the Canadian government and the Department of Justice do with the recommendations of the inquiries into the wrongfully convicted that are set up with the intention of preventing future miscarriages of justice. While you wait, you know that your life has changed forever and you will never get back what you lost. But you hope that in the end, fairness, reason, rationality, and justice will prevail. Thank you.